We're going to be learning about Articles 2 and 3 this morning. And Article 2 begins on page 9 in your George Washington copy of the Constitution. And we have a shortened class due to the length of the previous class, which was outstanding. Yeah. So we're going to go a little quicker in some areas and shorten some of it together. Is everyone on page 9? Okay. Yes, Mrs. Haragers, Mr. McManus would like, he's missing, he doesn't have a copy. Thank you. Okay. Article 2 is the, Article 1 was which branch of government? Article 1 was... Yes, legislative or lawmaking branch of the government article. Okay, we were learning about the executive or the presidency, Article 2. Okay, page 9, section 1. Let's read this together, starting with the executive power. God bless you. Okay, everyone see that? The executive power? Let's read it together. The executive power shall be vested in a President of the United States of America. Stop. So the executive power is vested. Remember we talked about that word? I'm trying to remember who was the instructor that talked about that. Mrs. White, that's right. And she talked about vested means the power is placed into. So it is placed into the President. Let's go with he shall hold. He shall hold his office during the term of 4 years, and together with the Vice President, chosen for the same term, be elected as follows. Okay, stop for a moment. Okay, it is worth noting that the way the Founding Fathers created electing presidents is not really the way we elect them today. There are still some aspects of the way we elect the president today that do go back to the 1790s. The term electoral college, I don't actually even believe it appears in this document, but the Electoral College is the way we elect the president. But in the very original years, the way the Founding Fathers created it, and we're going to walk through this together, is that citizens voted for members of their communities who were respected citizens, and those respected citizens would become electors. Say electors. Okay, and those electors would get together, would congregate at a meeting, and they would vote, and they would elect the president. Okay, so that's a short synopsis of what we're just about to go through together. Let's see if we're together. Okay, so starting with each state. Each state shall appoint in such manner as the legislature thereof may direct a number of electors equal to the whole number of senators and representatives to which the state may be entitled in the Congress. But no senator or representative or person holding an office or trust or profit under the United States shall be appointed an elector. All right, so basically what the Founding Fathers said to us is if you're a senator or if you're a congressman, you do not become an elector. Okay? Right, the number is equal. So in New Hampshire, my home state, we have 2 members of Congress and we have 2 senators. Okay, so we get four electors. 2 for the 2 senators, 2 for the 2 representatives. I'm trying to think. Let's see here. Who lives in another state? What state do you live in? Oh, Michigan, right, okay. So how many representatives are there in Michigan? I think, are there 15?
14 or 15.
14, okay, let's just say there's 15. Michigan would have 17 electors, 2 for the 2 members of the U.S. Senate, and then 15 more for each member of the House of Representatives. Okay. Okay, now we're going into, you will notice that there is a bracket on the word "the." Okay? That means that this section of the Constitution has been superseded or become reworded. Thank you. But we're going to go through it anyway because it's important to understand the way our founding fathers were thinking. So let's do this together, starting with the electors. The electors shall meet in their respective states and vote by ballot for 2 persons, of whom one at least shall not be an inhabitant of the same state with themselves. And they shall make a list of all persons voted for, and of the number of votes for each, which list they shall sign and certify and transmit sealed to the seat of government of the United States, directed to the President of the Senate. Stop. So, the reason why, did you catch how they could not vote for 2 people of the same state? One person had to be an inhabitant of another state, and that was in part to prevent a very large state from nominating 2 people from that state. In other words, to divide the power. We talk about checks and balances with the Constitution. This is a tiny, minor check on power. Okay, and then let's see. Okay, starting with the President. The President of the Senate shall, in the presence of the Senate and House of Representatives, open all the certificates, and the votes shall then be counted. The person having the greatest number of votes shall be the President, if such number be a majority of the whole number of electors appointed, and if there be more than one who have such majority and have an equal number of votes, then the House of Representatives shall immediately choose by ballot one of them for President. And if no person have a majority, then from the 5 highest on the list, the said House shall in like manner choose the President. Okay. Who's the one President of the United States that was elected unanimously? Yes, George Washington. George Washington. And George Washington actually did not want a second term. Actually, he didn't even want a first term. But he did not want the second term. And what the electors did was they were so concerned about someone who was not able to hold things together as well as George Washington was able to, that they met privately, voted for him, and elected him for a second term. And that's why, by the way, if you've ever noticed, Washington's farewell address was in the middle of September of 1796. Most presidents give their farewell address in January, okay? But Washington gave his farewell address, which was actually a printed document. It was not a formal speech. But he gave his farewell address in September, 4 months before. Why do you think that he did that? He did that because he did not want to be nominated for a third term. Because Martha wanted to go, and he and Martha both wanted to go back to Mount Vernon. That's why. Okay, so the president and the vice president were elected by this method for the first several presidential cycles. Okay, but when parties began to develop and became powerful, it became apparent that a president could be elected from one party and a vice president could be elected from another party, and with those two people not having the same beliefs, folks came along later, and that was how the Constitution was amended. And so the president and vice president today run as a ticket. Okay, let's drop down to, what's my time?
Very short. We're getting through 2 articles.
Yeah.
10:30.
Okay, so let's go down to, you want section 2, did you say? Yeah, let's do that, yeah. Okay, let's go to section 2, page 11, the middle of the page. Okay? The president, let's read it together. The president shall be commander-in-chief of the Army and Navy of the United States and of the militia of the several states when called into actual service of the United States. He may require the opinion in writing of the principal officer in each of the executive departments upon any subject relating to the duties of their respective offices. And he shall have power to grant reprieves and pardons for offenses against the United States except in cases of impeachment. Okay? So you'll notice that throughout this article, it talks about we elect a president. But I notice often in the news, when folks are campaigning for the presidency, or they're campaigning for somebody on someone else's behalf, they often say, we will elect a commander-in-chief. Is that accurate?
No.
It's not really accurate. We really elect a president. The president becomes the commander-in-chief when, and you went through this with Mrs. White, Article 1, Section 8, I think it's Clause 5 or 6, Congress declares war. And when Congress declares war, the president becomes the commander-in-chief. Okay? So unless we're in war, we're not electing a commander-in-chief. We're electing a president. It's a very fine nuance. However, it's important because I believe that there are many people who are trying to create a more powerful presidency. And that's not the way the founders intended it. And then, of course, the president has these amazing powers that it does grant. He can pardon. He can offer pardons. He's not able to offer a pardon in the case of an impeachment. What is an impeachment? Andrew.
When someone in a position of government is going through the process of taking.
Could you stand up and say it louder because I'm not able to hear it? The fan is loud.
When someone in a position of government is taken from their post because of
that is that's the result of the conviction. Yes.
When there's enough evidence of a crime to take them to trial.
Right. Yes. It is a charge. It is a charge or an indictment for someone holding public office. Okay. Many people think an impeachment is removal from office, but that's not what it is. Right. It's an indictment or a charge, an accusation, really. Okay. With a conviction, it becomes removal. Okay. Okay, next paragraph. He shall have power. Let's read it together. He shall have power by and with the advice and consent of the Senate to make treaties, provided 2/3 of senators present concur, and he shall nominate, and by and with the advice and consent of the Senate shall appoint ambassadors and other public ministers and consuls, judges of the Supreme Court, and all other officers of the United States, whose appointments are not herein otherwise provided for, and which shall be established by law. Stop. What happened last year? There was an enormous media frenzy about one of the current president's appointments. You remember which appointment that was? He needed the advice and the consent of the Senate. Gabe. It was for the U.S. Supreme Court. Yes. Yes. The president nominated Judge Kavanaugh for the U.S. Senate, and there was an enormous for the Supreme Court, enormous hullabaloo in the media and in the Senate about that appointment. Okay. Most appointments get very little publicity. There are usually, I think, hundreds of appointments made each year. Rarely do they make any more than a blip in the news. In fact, I believe Kavanaugh himself had been approved by the U.S. Senate for one or two previous posts, and very few people even knew that. Okay. All right. Okay. What if Congress is not in session? Well, on the top of page 12, that first tiny little paragraph, it starts with the president. Let's read that together. The president shall have power to fill all vacancies that may happen during recess of the Senate by granting commissions which shall expire at the end of their next session. What does recess mean? Does it mean time to run out on the playground and go on a swing?
Why not?
Is that what the senators do when they're in recess? Yes, Andrew.
Recess is typically a break in either a court proceeding or in Congress.
Very good. It's a break. Yes. Okay. Yes. President Reagan went to address some of the teachers one time in the 1980s, and he said, when Congress is not in session, it's no accident that they call it recess. But that's when the president has the power to make a nomination to fill a vacancy without approval of the Senate, is during their recess. Okay. Section 3, we're going to talk about the State of the Union addresses. When does the State of the Union address usually occur? Does anybody know? Yes.
When the president is being sworn into office.
Actually, that's correct. Yeah. For some reason, it happens to be at the end of January, and presidents are sworn in the middle of January 20th or 21st, and then usually in late January is when the State of the Union occurs. However, we're going to find out what the Founding Fathers said about State of the Union addresses, okay? So let's read Section 3 together. He shall, from time to time, give the Congress information of the state of the Union and recommend to their consideration such measures as he shall judge necessary and expedient. He may, on extraordinary occasions, convene both houses or either of them, and in case of disagreement between them with respect to the time of adjournment, he may adjourn them to such time as he shall think proper. Okay, stop. Okay, so basically it just says that the president shall do a State of the Union address from time to time. But I think going back to about 1800, the tradition has been once a year. Okay. All right. Thank you. Okay. Article 3. Actually, let's do section 4 as well. The president. Let's read section 4 together, starting with the president. The president, vice president, and all civil officers of the United States shall be removed from office on impeachment for and conviction of treason, bribery, or other high crimes and misdemeanors. Okay, so that sentence does help it become a little clearer that the word impeachment is very incorrectly used, especially in the media today, where they make it seem as if impeachment means removal from office. Okay, impeachment does not mean that. What's the word that begins with a C that causes a public servant to be removed from office? Conviction. Okay. Okay. So, Article 3, Section 1. So, the first article is the what branch? Legislative, right? Or lawmaking. The second article is the executive branch, right? And the third article is going to be the judicial branch, okay? All right, let's look at this together. Section 1. And we'll read it all together here. The judicial power of the United States shall be vested in one supreme court, and in such inferior courts as the Congress may from time to time ordain and establish. Okay, stop. Okay, so you notice how it says Congress may establish courts. That means that Congress can unestablish those courts if those courts are not behaving in a lawful way. I think that's something that probably most members of Congress, if they're even aware of, would never dare to even bring up. Talks about the Supreme Court. How many justices does the Constitution say should be on the Supreme Court? We just read it. How many justices on this court? Doesn't say, does it?
Yeah, it doesn't say.
No. So, Congress, many years ago, made the law that there be 9. Okay. In fact, originally, when George Washington was president, God bless you, when George Washington was president, there were, does anybody know how many there were on that court? What'd you say? 7? Okay, that's a good guess. It's not right, though. But you get a fish for trying. Yes?
5.
That's another good guess. Wrong. There were, did anyone, since we've already ruled out 9, 6, and 5, 9, 7, and 5, who wants to make another guess?
4.
Wrong, but good try. Thank you for participating. Yes. 6. That's right. 6 justices on the very original Supreme Court. And that was like that for about, I'm going to say about 35 years, I believe. 35 years, something like that. And then Congress made a law and said there shall be 9. Okay, and how many are there today? 9. Okay, so it's been like that for almost 200 years. Okay. Now we're going to find out how long judges serve. Okay, so the next sentence starts with the judges, the 4th line. Okay, let's read that together. The judges, both of the supreme and inferior courts, shall hold their offices during good behavior and shall at stated times receive for their services a compensation which shall not be diminished during their continuance in office. How long do justices serve on a court? Yes. Stand up and say it louder. Life. How many people say that's right? How many people say it's not right? Okay, and why? And Caitlin, why do you say it's not right? What a scholar! I am so impressed. She said, while they are in good behavior. In good behavior. However, the media, which we hear sometimes 3 or 4 times a day, 7 days a week, 365 days a year, will tell you what? Several of you said it. That it's an appointment for life. Okay, it's not. It's an appointment for during good behavior. Okay. Section 2. Okay, and we're going to be covering Mrs. Harper's favorite sentence in the Constitution. Okay, Mrs. White covered Mr. McManus's favorite sentence in the Constitution, which is Article 1, Section 1, Sentence 1. But I think I got that right, didn't I? Yeah. Okay, and but we're going to be covering Mrs. Harper's favorite sentence very soon here. Okay. Okay. Actually, let's skip down to the second paragraph, starting with "in all cases." Okay, everybody there? Okay. In all cases affecting ambassadors, other public ministers, and consuls, and those in which a state shall be party, the Supreme Court shall have original jurisdiction. Okay, stop. Okay, now we're getting to this very exciting sentence. Start again. In all. In all the other cases before mentioned, the Supreme Court shall have appellate jurisdiction both as to law and fact, with such exceptions and under such regulations as the Congress shall make. So this is a 1780s way of saying that Congress has authority over what cases the Supreme Court can hear. Okay? So if the Congress doesn't want the Supreme Court to take on a case, Congress can tell the Supreme Court, you will not take that case. And also, the Supreme Court hears cases that really it shouldn't be hearing. The Supreme Court is ruling on all sorts of subjects that have nothing to do with the Constitution. Marriage, for example, if you go back to the time of Christ, or even thousands of years before that, marriage was a husband and a wife, a man and a woman, okay? Before this country was founded, okay? So why could the Supreme Court hear a case and then tell the citizens how the government must define marriage and to change the definition? So that is a case where Congress could have told Supreme Court, don't take the case, and Supreme Court should not have needed to be told. The Chief Justice and the justices should have known outright, this is not something that we should be ruling on. Okay. Well, did you want to add something, Mrs. Harper?
Yeah, I'd just say that domestic law belongs to the state level. So marriage, divorce, adoption, those laws belong in the states. And when a particular state has granted something, the other states need to honor it. That's in Article 4. But the key thing is that the Supreme Court is inventing rights that are not right. And it's pretty obvious to any normal moral human being, I believe, that killing one's young is not something that the government should say has to be legal in all 50 states.
Right.
So they never should have been allowed to take that case, or having taken it, they should have listened to Ron Paul with his Sanctity of Life Act when he was in Congress. He was in Congress a long time, but at one point he brought this up so that this could have been rolled back. The Supreme Court has been wrong in the past and been overruled by a later Supreme Court. And it could, Dred Scott, you can look that one up. But these instances, the Supreme Court should not be messing with the dictionary and rewriting what things.
Section 3. And we're out of time, but I'm going to take another minute or two. So, Section 3, let's read this together. Treason against the United States shall consist only in levying war against them, or in adhering to their enemies, giving them aid and comfort. Stop. So, treason is giving the enemies of your country what? Aid and comfort. Okay, let's say that all together. Aid and comfort. Okay. And we'll go on. No person shall be convicted of treason on the testimony, unless on the testimony of two witnesses to the same overt act, or on the confession in an open court. What is an overt act? What is an overt act?
Like a purposeful act, something that is not like...
That's right. A purposeful act, and also in the open. Overt is right out in front of everybody. Like when I shake this camper's hand, that is an overt act. Okay? It's right out in the open. All right. I want to thank all the campers and everyone today, Mr. Melfa for filming. This class is now over. If you have any questions, please see me after class. We will be back here at 11 o'clock, right? 11 o'clock. Thank you.
Thank you.